Yeah, we do have one card in opposition. Okay, we'll set the motion to the side for a moment. Mr. Richard Ducote, on behalf of himself, he's an attorney, would like to speak in opposition.
Yes. Good morning. Thank you very much. My name is Richard Ducote. I've been a practicing attorney in Louisiana for 41 years, primarily devoted to domestic relations law. I have a master's of law in child and family law. I've handled domestic relations cases in at least 50 courts in this state. I've tried custody cases and abuse cases in over 45 other states. And I can tell you this is a very, very bad bill. What has been represented as very minor changes is absolutely incorrect. This bill has very drastic changes to the current parent coordinator statute in, I think, very concerning and unconstitutional ways. So first, let's talk about what parent coordinators are. Parent coordinators are an entity that are used in a minority of states, and it's a little hard to pinpoint because there are some states that allow them by court rules in particular jurisdictions, but no more than 15 to 17 states have parent coordinators. So if this is the greatest thing since sliced bread, it would be universally accepted. It is not. So what happens in a custody case? What's supposed to happen under the law in a child custody case is under Civil Code Article 132, the court either designates a sole custodian or a joint custodians with both parents. If you have a sole custodian, that parent makes all the decisions. As a matter of law, this legislature has determined, and I've been involved in drafting now over about 30 pieces of legislation that this legislature has enacted. If you have a sole custodian, they make all the decisions. That's the way it works. In a domestic violence case, you can only have a sole custodian. You can't have joint custodians under Act 412 that the legislature passed last year, which is a great bill. But this bill allows for parent coordinators in domestic violence cases by agreement of the parties. Well, that shouldn't even be in there. That's a non-issue. If you have a joint custodian arrangement under Article 132 of the Civil Code, you have a domiciliary parent who ultimately has the authority to make decisions in the event of a dispute. Or under RS 9-335, you have a joint custody implementation plan which allocates which parents make the decisions. Okay, so what happens is this bill is touted as a way to diminish conflict. It does just the opposite, because the judges will lay out a custody decree that says who can make the decisions. If you have a parent coordinator in place, then after the parents have already spent money for attorneys to get the divorce, custody evaluators to get a final custody decision, and now under this bill 2 more years of parent coordinators that these parents have to pay for all these sessions to resolve issues that they have no business resolving. And if you look at what the parent coordinators are supposed to do, help the parents resolve how kids are supposed to get a haircut, whether Johnny plays softball or not, whether somebody gets piercings or tattoos. That should already be in the custody decree. So what you have is usually a parent who wants to foment discord will run to the parent coordinator, will say, look, this parent, although they have the authority to make decisions, I think they should make another decision. I disagree with that decision. So the parent coordinator, who has absolutely no moral, no emotional, no interest in the child other than having that job, getting a couple of $100 an hour to sit there, will say, well, I think Johnny should play softball. Well, if the other parent who has the authority doesn't want that to happen and says, well, no, I think he ought to play soccer, then the parent who disagrees runs to court. Oh, this parent's not accepting what the parent coordinator says. So then you have a whole new line of litigation. Everybody's paying for attorneys. Frankly, and I'll be very honest, it's a racket. Parent coordination is a racket. Now, what does this bill do? It's represented, well, we need more parent coordinators because we have a shortage of parent coordinators. We don't have a shortage of parent coordinators. We have, on the website for parent coordinators, Louisiana shows 57 parent coordinators listed, more than any other state I could find. Kentucky has 5, Alabama has 4. 57, that's more than we have judicial districts. There's no shortage of parent coordinators. Now, the bill allows for lawyers to be appointed as parent coordinators. Well, why is that in there? I'll be very honest. It's so the judges can appoint friendly attorneys to get these fees as parent coordinators. It's very, very disturbing. There are additional problems with the amendments here that are not minimal by any means. So under 358.1A, what the amendment would do would change the current law from a parent coordinator being able to be appointed after the court has already entered a custody order. It would change that to say that the court can appoint a parent coordinator before there's any custody decree. Well, what would that be? That is a wholly inappropriate delegation of judicial authority to a social worker, a psychologist, a lawyer, whatever. But on what basis? What can they do? They sit down with the parents don't agree, they spend money, they have to go to court anyway if they can't agree. So it's a churning operation, unfortunately. Then you look at B. The initial term of the appointment of the parent coordinator shall not exceed, it was 1 year, now it's going to be 2 years. Well, what's the reason for that? More fees. It prolongs the litigation. It provides a forum for people who should have things resolved by a court decree to be able to go and churn up controversy with the parent coordinator, again, who has no interest, and
So
you end up back in court.
And we have a question from Senator Milkovich.
Yes, sir.
This is, I guess, a simplistic approach, but it seems like we're interposing more and more. And listen, I have to pay respects, and I'm not going to say with all due respect. I have to pay respects to our great, wonderful colleague Chad Brown in the House. Does a great job for his constituents. But it seems like we're imposing more and more government into interpersonal relationships. Why do we need a government? I'm sorry, I'm going to lower my voice because Chad's a great legislator. Why do we need to appoint one more level of government intervention to mediate interpersonal familiar relationships? I mean, I guess what I'm telling you is I'm agreeing with you. Do you agree with that, with what I'm saying?
Oh, absolutely. That's why, when I read this bill, I was appalled because, first of all this, there's been no study about what the effect of parent coordinators are. There was one attempt in Ohio, a very comprehensive study done by the Ohio court system that looked comprehensively, and they actually put out a report. It wasn't just anecdotal things that people told the Law Institute about this is a great idea. But the ultimate conclusion is, well, we really can't find any benefit to parent coordinators. We need more studies. Well, it's a self-defeating prospect. And if you look at what the bill does too here, it says if the parents can't afford to pay, if they're paupers in the court system, if they're both paupers, we won't have parent coordinators unless we can have a volunteer parent coordinator. If one of them is a pauper and the other one's not a pauper, then the court can impose a parent coordinator. Well, then guess who's going to pay all the fees of the parent coordinator? The parent who's not the pauper. So you're absolutely right. The benefits of these are I think very, very hard to find. There are lots of problems. When you go and
thank you, Mr. Chairman. That was on my question. And I'm sorry, I don't mean to interrupt you from your.
Sure. But if you look at again, it's represented, well, this isn't a big deal, it's just a little cleanup. Absolutely not. If you look at F, this is on page 4, paragraph C, it says a parenting coordinator shall, and the current law says, refrain from facilitating an agreement by the parties that would change legal custody from one party to the other, or that would change the physical custody or visitation schedule in a way that would result in a change in child support. That's the current law. This bill eliminates that provision whatsoever. So what this bill would do would be to authorize a parent coordinator to try and force an actual modification of the custody arrangement that a court has already decreed. And what happens is, you often have a disparity in power within these relationships in the couple. You get heavy-handed parent coordinators, and then, if one parent tries to change custody with this, not a judge, but somebody appointed to, and is getting paid to do this, it's just chaos. And then I would get to the most frightening of all of these, and that is, if you look at 358.6, it says, the parenting coordinator shall not communicate ex parte with the court except in an emergency situation. The new language is the parenting coordinator may inform the court of an emergency situation without notice to the parties. So you can have this parent coordinator run into the judge in chambers and going, oh, judge, I think this, you ought to do this. And if you look at the revision comment, again, this is wholly unconstitutional. The communication of an emergency situation without notice to the parties is designed to allow the court to act swiftly and effectively when, for instance, the parenting coordinator suspects that a party will wrongfully remove a child from the jurisdiction of the court without prior court approval. So this bill allows a parent coordinator to run ex parte, and if you look at deprivations of due process, ex parte communications with the judge is universally condemned as one of the most egregious detriments to constitutional due process. This bill says, if the parent coordinator suspects, they run to the judge and the judge can start issuing orders. This is a very big problem, and I'd ask the committee to reject it. We don't need it. It creates more problems than it solves, which I don't think are any.
There's one other card in opposition, but does not wish to speak. But before, did you ever go, or were you privy to any of the Law Institute discussions?
I was not. I was. And I know judges, if you look at who was involved in this, judges are very happy. They love this because they can delegate their judicial authority. Great, wonderful. And then they get to make appointments. And then you also have mental health practitioners on there who will benefit from these coordination appointments. But no, I was not involved in it. And I looked for a report on the Law Institute website to see where it was that they found that these things were terrific ideas, and I don't see that. I just see that who's on the Family Law Committee, and I'm familiar with the folks on that committee, and they're fine people, but I know what the agenda is. So,
all right. The other